Project delays, redevelopment issues, society formation, or creating gift deeds. If you have any legal query regarding property, you've tuned into the right show. Very, very warm welcome from Magicbricks Now. This is Property Hotline, the show that answers all your real estate queries. I'm Kavita Krishnan. Our expert for the day is Hemang Jariwala. Hemang Jariwala is an advocate at the Bombay High Court. And yes, we are answering all your legal queries today. Let's take an email query first, Hemang. Mohan says that he bought a flat in an apartment in Bangalore's developing area. Now, the owners are confused regarding which act they should register the owners association under, the Societies Act or the KAOA, which I gather is the Karnataka Apartment Ownership Act. Now, Mohan also wants to know what is the cost involved for the registration, and he also wants to know what the pros and cons of each act are. One quick tip for Mohan before we bring in Hemang, you can actually find all acts online. The entire act will be available online. So the pros and cons in detail, if that is something that you really want to know, you can actually go and read the act and educate yourselves. Hemang, very quickly, can you solve this
basically,
problem?
Mr. Mohan, what happens is that when the flat purchasers are coming as a group, then it is always better to go for a society formation, because notionally what happens under the provision of the Societies Act, the land and the building is owned by the society. So nobody tries to claim the ownership of the society as a whole. While under the KAOA, which is the Apartment Ownerships Act, it is a formation of a condominium wherein each and every flat purchaser would be a part owner of the land and the building, wherein there is always a clash of egos between members or flat purchasers saying that, I am also the owner, you are also the owner, so who's going to listen to whom? While under the society, there is a hierarchy of deputy registrar, district deputy registrar, divisional joint registrar. So there is a proper panel and levels of quasi-judicial authorities who can resolve any mismanagement or dispute amongst members also. So a society formation is always better than a condominium.
Also, you did mention, Hemang, the judicial structure that is already in place for a society.
Yes.
If you need to seek redressal, is there any such judicial structure in place for condominiums? Or
There is the deputy registrar who looks after the society also has been given an additional charge to look after the condos also. But as Society Act, like in Maharashtra, it is the Maharashtra Cooperative Society Act 1960. So for the past almost 56 years, the act is in place, the laws are in place, the judgments are already settled laws. For example, parking issues, dispute redressals, mismanagement, then deemed membership, all those judgments, all those provisions are so very clear that if a society is formed, then the members are well protected under the provisions of law as well as amongst themselves also.
Okay, so because the Societies Act, you're essentially saying that since the Societies Act has been in place for a far longer time, it has a proper structure, and you have a judicial structure in place. There are laws, there are precedents, there are judgments, so you're better off, registering yourself under the Societies Act. Moving on, we have Kamna, who's dialed in from New Delhi. Kamna, how can we help you?
Yeah, I can hear you. Hi, sir. I would like to seek your expert opinion regarding the status of title to this property. The facts are that in March 1955, a plot of land is purchased by the person through registered sale deed from another person. Then, in September 1955, an agreement of sale is executed between this man and DMC, Delhi Municipal Committee, under the Northern City Extension Scheme number 1 Sabzi Mandi, and the purchaser pays another around 2,600 rupees for this. Then further in 1958, an indenture is made between DMC and this purchaser, where DMC mentions about seizing this plot under the scheme and confirms the sale to him again at that price which he has already paid to DMC in 1955 September. Now, in the same document, as per the request made by this man, DMC conveys the sale of this land in joint names of him and his wife. So my query is that who holds the title to this property? Because in the later years, this man before his death, he divided all his property between his sons in his individual capacity, and the wife never became a part of it.
Okay. So you want to know whether the wife still has any rights in that property?
Yeah, is this man the actual owner? Because there are two documents about his ownership. One, the 1955, and another 1958 document.
And you also mentioned, Kamna, let me just get this very clear. You also mentioned that there was a document of ownership, of joint ownership, in fact, that was issued in his name and his wife's name, right?
Yeah, that was issued by Delhi Municipal Committee in 1958 only, whereas the same plot has already been purchased by this man for around 12,000 rupees in March 1955, and that is a registered sale deed. And then he pays at the rate of rupees 10 per square yard, and another agreement is made between him and DMC that is regarding some construction of the house on this property.
Okay.
So I am not clear who holds the title to this property, this man or the property is in joint names now.
So who holds the title to the property?
No, basically I have understood, Kamna, is there is one gentleman in 1955 as well as in 1958, he has been the owner of the plot of land. In 1955, this gentleman sells to the other gentleman, okay, a plot of land or whatever which is through a registered sale deed. Correct?
Yeah, correct.
So the person who is having a duly stamped and registered sale deed or a conveyance deed, that person has now become the owner through that document, because in the year 1955 the ownership has shifted from this gentleman to the person who has purchased it in the year 1955 through a valid document. So the question of the wife or somebody else trying to claim the title would not arise, because in the year 1955 the seller had full right to sell that piece of land to this person who has purchased this through a valid document.
Yes, so can we consider this document executed by DMC as some sort of development charge, because this land was seized under this Northern City Extension Scheme number 1?
No, what I am trying to say, once an agreement which was executed in the year 1955 to this other person, have you brought that to the notice of this competent authority?
Yes, it is a registered document. I have got it from the copy I have got from the registrar's office only.
Yes, but have you brought that to the notice of the competent authority that now I am the owner of the piece of land?
Yeah, actually I have only got a portion of the property now from one of his sons.
Okay, but in any case, that gentleman who had purchased it through a duly stamped and a registered document, he is the owner, so the title will flow to you if you have in subsequent, you have purchased it or it has come through inheritance to you.
I have purchased it, and the father also sells the property to one of his sons.
That is irrespective, madam. Maybe this gentleman had...
So essentially, Kamna, what has happened is one person bought the land, sold it to another person, and this person who bought this land then divided it among his 4 sons, and one of those sons has sold the property to you. So what Hemang is trying to tell you is that since this person did buy the land from the original owner and has documents to prove it, it means that he is the owner, and since he is already divided it, passed it on through a gift deed to his 4 sons, the land title will flow to you. So in that sense, if you have bought it and registered the agreement, then you are also the owner of that particular plot of land. However, since you are very worried on this particular aspect, what we suggest is now the advice that we are giving you is basis whatever you are telling us on the phone line. The best thing for you in this case would be to go and actually consult a property lawyer and get a proper title check done, which will reassure you that you are the rightful owner of the property, right? Thank you very much for calling in. We have Jalota Anil Kumar now, who's called in from Thane. How can we help you, Anil?
Yeah, madam, you see, I purchased a flat from a highly reputed builder on Kalyanchil Road and took possession recently on 16th of April 2016.
Okay.
Delay has been more than 2 years from the promised date as OC was not available. Now, my query is that at the time of paying the last 5%, the builder recovered rupees 20,000 for formation of society from each owner. With 500 flats, it amounts to almost 1 crore of rupee. Now, my question is, whether is it legal? And if it is not legal, what is the remedy available to individuals and the society? Because I feel no money is required for formation of the society. Formation of society is by the members. And at best, the builder can be a facilitator, nothing more than that. And over and above this 20,000 rupees, they recovered tax on society for 31,000 rupees from each member. I would like to know what is the legal remedy available to us.
Anil, you also mentioned there was no OC. Do you have OC now that you all have taken possession?
I got permission. I got possession only after obtention of OC, not otherwise.
Okay, so you've taken possession after you got the OC. So he at least has that in place. But does he have to pay all these charges?
See, basically, if you see the agreement which has been executed between you and the developer builder, in the agreement he would have mentioned the charges for formation. Are the charges for formation mentioned in your agreement between you and the developer?
Anil?
Yeah.
Does the agreement say that you have to pay any charges for forming the society to the developer?
Yeah, it was mentioned in that agreement.
Correct. So basically, you have signed a contract or you have signed an agreement wherein you were informed that X amount will be charged for formation of the society. Right? Now, under the Maharashtra Cooperative Societies Act 1960, okay, a developer is duty bound to form a society.
Right.
Right? It is his job to collect all the names, complete all the formalities, give it to the deputy registrar, which incurs a cost, that is a legal cost and a procedural cost.
Sir, they have recovered the legal cost separately.
No, so I'm coming to that. So first of all, suppose in the agreement they have said that it would be 20,000 rupees.
Right.
And suppose later on they have again collected 31,000 rupees per member. Okay, then that collection of 31,000 is absolutely illegal. Right? So for that you have to shoot a legal notice and under a class action, because it has been collected from these 500 flat purchasers. Okay, so you can go under a class action under the Consumer Protection Act, because this tantamounts to deficiency in service, because no member or a flat purchaser can be charged twice, first 20,000 and then 31,000 for the same thing.
This 31,000 rupees in the name of service tax.
Service tax for what?
Service tax on society.
The service tax
for
from
society.
Or the service tax for formation society. What does it say? What does the receipt say?
Receipt says service tax on society.
And per member?
Per member.
No, I think there is something
that
wrong.
is a
There is
service
nothing like
tax.
service tax on society. I think you got to approach the consumer forum with this. Okay, first of all, send a legal notice to him. Try to find out what exactly is this 31,000 for. Okay, if it is a service tax, then ask him whether this amount has been paid into the government treasury or not. Right? And if it is not done, then please approach the consumer forum immediately under a class action and recover this money with interest.
You know, Hemang, he also asked if there are any individual remedies that he can look at, because I'm sensing here that probably other people in the society probably don't want to go along with him. In that case, can he send a legal notice individually and also take action?
All rights are individual only. So he can send a legal notice himself and also approach the consumer forum in his own name.
So that's it, Anil. There are you have two remedies. You can file a class action suit as a group, or you can approach the consumer forum on your own. However, before you do that, do check what the service tax was collected for, whether it was for the society or whether it was from the buyers. and check if that service tax has been deposited in the government treasury. Right, moving
Okay.
on, we have Mr. E. Koshi, who has sent in a question now on our website, www.mbnow.in. Now, Mr. Koshi wants to know if a developer selling a new flat can make the buyer purchase the flat on an as-is where-is basis. He also wants to know what is an as-is where-is, what it means. Additionally, he asks if a developer sells units on an as-is where-is basis, can he build without following good engineering practices or the laws and the rules of the local authorities? Now, Hemang, generally as-is where-is is used if you're selling a property that already exists, right? That's a term that banks use for prepossessed properties.
Yeah, see what happens is as is, where is, what is basis means that whenever there is an auction of a flat which has been acquired either by the bank under SURFACE Act or some other agency, they put it on as is, where is, what is basis to the proposed purchaser that look here, this is a flat for sale or for auction. These are the liabilities which are known. But in case of any other liabilities which are unknown to us, and once you become an auction purchaser, then we are putting you to notice that if there is any other liability attached to this flat, then you will be responsible to make payment for the same. That is the meaning of as is, where is, what is basis. Here in this case, please do not buy any flat or property from any developer who comes up with such as is, where is conditions, because this is absolutely illegal and unlawful. Okay, there cannot be any condition of such type of selling a flat. Point number one. Point number two is, in case any such developer has written some as is, where is basis, okay, he is bound by the provisions of the law which is applicable to the housing sector, construction industry, and all the laws have to be followed by him, right? And also he has to follow the good structural and engineering norms which are required to construct a building. So just because he writes an as is, where is basis doesn't mean that he can use third-rate material or promise you some amenities, facilities, and thereafter not give you. But as a principle, do not enter into any agreement or do not buy any property from a developer who comes up with this as is, where is basis scheme.
And essentially, he also cannot sell you a new flat on an as-is, where-is
Absolutely.
basis. So, that word itself should raise a red flag and you should go running away from that particular developer and that particular project. That's our answer for you. Facebook query coming in next. Rakhi Singhal says that she's looking for a property in Bengaluru and she wants to know what kind of approvals are required for a legal property. She also asks, how can you find out whether the property has all the approvals in place? Hemang, I would want you to answer that second question first, because that's something that viewers keep asking us, and it's all very nice for us to sit here and say, do your due diligence.
Yeah.
But how, as a lay person, how do I do my due diligence?
I think it is a matter of time. We should be thanking this present central government who have come out with an act which is in short called RERA. Okay.
But that is 1 year away. I mean, by the time RERA comes into, and I can't really, what if I'm buying a flat today or tomorrow?
Do not buy. If you ask me personally, please do not go and rush into buying properties. Okay. The central government has come out with an act which is already gazetted in March of 2016. The states are very active in formulating their own rules. The central government under RERA has also put up the rules to the state. And it is a matter of time this RERA is going to come into force in each and every state. Lot of flat purchasers have burned their fingers, their hard-earned money. There have been cases of project delays, illegal constructions, which will be of a past the minute this thing comes into practice, into formation, into each and every state. Now, as regards this query which normally comes in, that which are the documents I should be seeing, please understand, under RERA, a builder will not be able to sell a single flat or a commercial premises unless and until all the licenses, permits, permissions from the various competent authorities are already obtained by the builder, submitted to the competent authority under the RERA, And once that authority has evaluated that all the permissions are in place, which includes title documents, IOD, CC, approved and sanctioned plan, TDR purchase, draft agreements with individual flat purchaser, draft agreement with conveyance, okay. All these things are going to be uploaded on a website. They would be given a registration number, right? And once it is been there on the website, you will be able to see everything transparently as to what are the sanctions given, what is the stage of construction, what is the permissions given by the competent authority, and at what slab the construction is at, and how much money has been taken from you, and whether it matches the construction levels. So if you are not in a rush, I would personally tell the flat purchasers, do not rush into buying, because there is an act which is in place. It is a matter of time, and your safety and safety of your hard-earned money is very important. So wait for some time, failing which, as I said, check the title document, check IOD, check the commencement certificate, check whether the TDR is in place or not. And once all that is there, also check whether the developer has the financial capacity to complete the project in time, or whether just take a search and find out whether there are litigations against that developer or not. So once you have done your due diligence, then you may go and buy. Otherwise, just wait for the state to implement RERA.
Wait for the state to implement RERA, and also, for the information of all our viewers who are tuning in, the government has also released a draft model agreement which it wants all states to adopt, and eventually all developers also to follow once it comes into force. Now, this is something that has been released just on August 1st, in fact, and we will be discussing this in detail in all our shows today. So do tune in if you want to know how you can safeguard your rights, and where you can go and actually read that model agreement. Also, one more thing, Rakhi, if you are looking for property in Bengaluru, and in case this property is anywhere near a lake, also do not forget to check for green approvals, because there's a very strong stand that the NGT has taken on buildings that are coming in and around lakes in Bengaluru. The building has to be at a minimum of 100 meters distance from the lake, if I'm not mistaken, but that is something that you'll also need to check out. We have another caller on the line now. Brigadier Tiwari has called in. How can we help you?
At the outset, Kavita, I wish to compliment your channel, because you guys are really doing a tremendous job.
Thank you very much. Thanks a lot.
Okay. And now my question is related to a property. I am trying to buy a flat where the payment is based on construction linked plan.
Okay.
Now, for construction linked plan, the builder is also charging the service tax every time that I am giving the installment at the rate of 4.5%. The property is at Lucknow. So I just wanted to check up the views of Hemang on this. Thank you.
Thank you very much for calling in, Brigadier. What do you say, Hemang? This is a question that, a lot of people are now asking. There is a lot of confusion on this particular aspect of service tax. Do I have to pay service tax every time I make a payment to the developer in a construction link plan?
See, if you are into a construction link plan, and if the state where you are in Lucknow, we are purchasing, then you have to pay the service tax at the time of the construction, so that once the construction reaches a particular level, okay, then that is where the tax comes into play, and which has to be paid, sir. So whatever they are doing as per construction, in a way it is a good thing that if they are going to the 10th slab, they are charging you as per the 10th slab, and that is where only they are charging you the service tax. So it is correct that you have to pay as per the slabs.
You can in fact see where the money is going. You can ask the developer to share the the receipt of the service tax that has been paid. There is a number, there is a tax number that that is issued to the developer, and you can actually check whether the money is going to the government treasury or not.
Correct.
That is something that you can do from your end if you want to see where your money is going. From Facebook, we now have a question on Twitter, I'm told. SP Rastogi has tweeted in his question. Now he wants to know if a builder delays delivery and response to a notice by denying that there was never ever an agreement, what should a buyer do? Now, this is very scary. So the builder's essentially saying there's no agreement.
Yeah, they would be basically coming up with such defenses, but important is that whenever you are buying any property, as I've always said, please do not rush into buying. Okay, take a mature decision, collect as much data, as much brochures, documents from the builder developer, okay, before going and making a payment, right? So you would be having a brochure, you would be having all the flowery leaflets which they would be inducing you into, right? Once you are convinced that, okay, I want to go and buy a property, whenever you make a payment, do not forget to take a receipt, letter of allotment, draft agreement. All these documents needs to be taken from the developer when you decide to buy. Thereafter, please on a regular basis, write letters to the developer builder, okay, as to when are you going to execute and register the document with me. Keep writing letters to them as to what is the level of construction it has reached, whether the plinth has come in, whether the first slab is come in, right? Please gather all these documents. Either the letters are sent by hand delivery or by a speed post AD card, so that you would be having the acknowledgement of the builder developer with you. So in case you need to have a case against him, you are fully geared up with all these documents in your hand, not giving him a chance of coming up with this excuse that there was never an agreement with you and hence please take a walk.
Right. Never a bad time to refresh the buyer's 101, the home buyer 101. Do keep this in mind if you are buying property. File every scrap of paper that the developer gives you. It is very simple. The brochure, the flyer, everything that the developer gives you can be used by you against the developer in a court of law if you do have to end up going to court. That is one. Secondly, ask for a copy of the agreement. You are well within your rights to ask for a copy of that. Take time, go to a lawyer, get the lawyer to go through the agreement and get it vetted by the expert so that you know what you are getting into before you sign on the dotted line. Do your homework, do your due diligence. Speak to buyers who have bought homes built by the developer earlier so that you can check on his track record, you can check on the quality of the product that he's actually sold to the home buyer. So you can do all of that. Visit the construction site at least 3 or 4 times before you actually sign on the dotted line, and keep visiting this and visit the site at different times during the day so that you can see whether or not there is any activity. Once you buy the flat, don't just sit at home. Keep visiting it. Check on the progress of the project. And like Hemang said, ensure that you register that agreement, start a correspondence with the developer and maintain a file, have a copy of every letter that you write to the developer so you have enough ammunition with you in case you have to go to court. That's it on today's episode of Property Hotline. Hemang Jariwala, thank you very much for coming in. If you have any questions related to real estate, do get in touch with us. We'll get the country's top experts to answer each and every one of them. Thank you very much for tuning in. Keep watching Magicbricks Now.
You can watch live TV on our website mpnow.in. Find us on Facebook at facebook.com/Magicbricks Now. And don't forget to click the like button. You can also follow us on Twitter at Magicbricks Now. To stay updated with all our programming, hit the subscribe button on our YouTube channel by logging on to youtube.com/Magicbricks Now.